Out to the new.
Of course, no, that's our.
And welcome this morning to the Ohio Elections Commission meeting of April 24th, 2025. We're starting at 10:04 today. Would you mind calling a roll?
Mr. Lyle. Present. Ms. Tavares.
Present.
Mr. Kirschner. Present. Mr. Caraway.
Present.
Mr. Knight.
Here.
Vice Chair Davis.
Here.
Chair Hagan.
Present.
All members are currently present before the.
Very good. Thank you very much. Our first order of business will be the minutes. Are there any questions over the minutes?
Mr. Lyle just moved approval.
Second.
Mr. Lyle seconded.
Okay, seeing a motion and a second. All in favor?
Aye.
Any opposed? Seeing none, that motion passes 7-0. We are going to move to the preliminary reviews category, the $50 fine of case 2024R-496.
First off, Chris, Mr. Egging or anybody related to 24R-496, no one is present, I'm presuming.
I don't believe so. I'm still double checking to make
Okay.
sure.
Okay.
But no, I don't.
Okay. Madam Chair, members of the commission, I thought we'd deal with this one quickly before going to the rest of the agenda. This was just a matter that we continued, I think, from February, actually. And in the intervening period, the report was filed, a response was submitted. You can see I gave an ICW to everybody. You can see my recommendations because the report was about 4 months late. The response was submitted. So my recommendation is to find a violation and impose a $50 fine. I'll be glad to answer the questions that the commission may have.
Okay, very good. Are there any questions of the commission members? Seeing none, is there a motion?
I move to adopt the executive director's recommendation.
Very good. A motion and a second. All in favor?
Aye.
All opposed? Seeing none, that motion passes unanimously. Okay, and for this next portion, we're actually going to allow Mr. Caraway to step out and Mr. Stoutberg to step in. Do we need to record Mr. Stoutberg on the roll as well?
I will do so, yes, but obviously, we can see here for purposes of record, Mr. Caraway has recused himself. Mr. Stoutberg is replacing him as will replace him as to this case. In this, Madam Chair, members of the commission, this is case number 2021 G-018, FC Freeman et al. The matter was originally addressed by the commission January 30. At that time, after taking a couple of actions that did not resolve the matter, the commission continued this case in an effort to or in an opportunity to give Mr. Hicks additional time to respond to a series of motions that have been filed by Mr. Hartman on behalf of Mr. Freeman. And so the matter was continued. It is now back before us. Mr. Hicks has filed a response. It was circulated to you. And so this matter is now back before the commission. I think Mr. Hartman wants to make a brief motion to the commission related to Mr. Hicks's submission. So we'll give him an opportunity to do that first.
Thank you, Madam Chairman. Kurt Hartman on behalf of Mr. Freeman. As the executive director just indicated in the January meeting, this matter was continued for further briefing. One of the provisos of that was that there would be sufficient time that briefing would be provided such that the commission would not get it at the 11th hour. Pursuant to that direction, the executive director did issue an order or notice of this hearing and set forth a briefing schedule for the parties. And specifically, it indicated, since we have been the movement, that the complainant would have to file his response by April 10th, and that any reply would be filed by April 17th. Mr. Hicks deliberately and outright ignored that deadline that had been set for him of April 10th, and thus filed a belated and untimely motion. And therefore, I would move to strike his response. Thank you.
Very good. We appreciate you. Are there any questions of the commission members?
Certainly, we could hear from Mr. Hicks. My recommendation would be to deny this motion and just allow Mr. Hicks to briefly address his motion before the commission and proceed, but it's up to the commission as to what they wish to do.
Is there any direction or will of the commission?
Madam Chair, if I-
Madam Chair.
Yeah.
No, go ahead. So is Mr. Hicks online, obviously?
Yeah.
Yes.
Oh, okay.
Yes.
Usually we have it up here.
Right.
Here, let me switch up there. My apologies.
He's right behind you. If you turn around, you'll see.
Okay. I couldn't see. Okay.
Our viewing is different today. Okay, very good. Hopefully that answers your question. Mr. Kirschner, did you have a motion or question?
I may, after we hear from Mr. Hicks, if he has a response.
Okay, so, very good. Mr. Hicks, would you like to offer your response?
I have my hand up. I don't know if you can hear me or not, if I'm muted.
Sorry, we had a little bit of dilemma or challenge here. We are not able to see you in front of us, and now we can. So we just didn't see your hand up, Mr. Hicks. So if you would, is it appropriate to be sworn in this?
Yes,
Yeah.
yeah, I'm sorry, yeah, Mr. Hicks would need to be sworn, then he can make a statement.
Thank you.
Raise your right hand. Do you swear affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Very good. Go ahead.
You're
We can
kind of
hear-
breaking up a little bit, but go ahead and do your best.
I don't know how I'd be breaking up. I have ample fiber. Can you hear
now
me
you're
okay?
not. Go
Okay,
ahead, I'm sorry, I
so
apologize.
Mr. Hartman, first off, I never filed a motion. The vote of the commission was that each side should file additional briefing relating to Mr. Hartman's motions 7 days, no later than 7 days before this hearing, which I filed 7 days before this hearing. Mr. Richter, for reasons I can't understand, and I immediately objected to, for some reason made me have to file 21 days in advance. But Mr. Hartman, once again, disadvantaging me. It's like, just like letting Mr. Hartman, it's funny, I didn't move to strike Mr. Hartman's motions even when he had put them in the night before the hearing, but the preliminary review last time. So it's very disingenuous. So Mr. Hartman also left out that I filed on March 7th an amended complaint. So he left that out as well. So I agree with the executive director's recommendation, but I'm also prepared because the briefing that I did in the middle of the night before Mr. Hartman's, after Mr. Hartman's last minute motions, has aged very well, and I can stand on that alone. In fact, I am prepared, whatever you do, I can address these matters based on what I filed on last Thursday. I can do it based on what I filed on the 29th. And I can also do it based on the March 7th amended complaint that I filed that's consistent with exactly what I said in the January 30th preliminary review. So it's disingenuous on Mr. Hartman's part. He has not filed. One of the issues, by the way, with his is that you guys already voted on his motions and you voted them down. 2 of them you ignored, 2 of them you voted down. Those motions never referred to 2 of the allegations at all that were in the original or the amended complaint at all. What Mr. Hartman's trying to do is avoid those. So it's curious that he never filed anything at all for this hearing to defend or to address, as I've called repeatedly for him to do, his response to 2 of the 4 allegations that were in the original and the amended complaint.
Very good. We appreciate your comments. For those who are visiting and viewing online, would you mind muting if you are not the speaker at hand? Sorry, we're having a lot of backgrounds feeding in. If you could just take a moment and mute your personal teams. Thank you very much. Okay, very good. Are there questions of the commission members?
Yeah, if I could, Madam Chair, just a question for the executive director.
Sure.
Were your orders violated in any way as it relates to this briefing schedule?
Well, the commission had said they wanted materials sufficiently in advance, and so the schedule I attempted to set was to give this, to allow Mr. Hicks an ability to submit as the commission requested. In the intervening period, Mr. Hartman had asked for an opportunity to respond, and so I thought giving that kind of a time frame wasn't unreasonable considering the time between when we originally addressed it and now. And so, yes, I did indicate, here's the time frame that I wanted to see that so that the commission could have material sufficiently in advance. Mr. Hicks did file a week in advance. That's still sufficient, I believe, for the commission to consider what he submitted. And so I was willing to go ahead and accept it and move it along to you in advance of this.
Okay, thank you.
Very good. Are there any other questions?
Yeah, well, I mean, right now what we have pending before us is Mr. Hartman's motion to strike. Like I said,
By the way, as a side note, wasn't he responsible for filing a motion to strike and serve it upon me before this? By your own rules, if he was going to have a motion to strike, he had to file that and serve it to me in advance. He did not.
He did not do so, but that's not one of the reasons, because I just feel like we should go forward based on the materials we have. So I'm recommending that we deny the motion to strike.
I move to adopt the executive director's recommendation.
Second.
Okay, very good. Seeing a motion a second, all in favor? All right. Any opposed? Seeing none, that motion passes unanimously.
All right, now we would hear from, if you have anything else that you would like to add to the submission that you previously made, you have that opportunity to address the commission, Mr. Hicks.
Mr. Richter, just before we begin, this is Trevor Stanley. Just want to make sure that our presence is noted on behalf of Susan Jones,
Okay.
just so you know that we're here. So Erica Prouty and I are here on behalf of her, so we intend
Okay.
to speak when that moment comes. Thank you, sir.
Thank
Thank
you.
you.
Thank you, Chair.
So is it my turn or what, or where are we?
Yes.
Okay, so I'd like to share my screen. Is that possible? I sent a note to Chris in advance.
You able to grant permission, Chris?
Well, let's see if let's see if it just lets me do it. I just said to do it. It did it?
Yep.
Okay. So everything in here is what I want to talk to, but also I put some clips out of the 2.5. I think all the clips are out of the thing I actually filed on January 29th, but I want to just give a quick flow of this. I think the issues before the commission that you believe are res judicata is the main issue that Mr. Richter seems to think that, or you guys seem to think needs to get covered. So I want to just cover, because this relates back to case 2020 G19, I want to give very quick background on that, talk about the current case and talk about how these cases are different. So 2020 G19, that case focused only on media, video and audio created, and it was all created by Strategic Media Placement and campaign consult, and it focused on campaign consultants, namely Stephen Caraway, Luke Householder, and RJ Mancini. No document showing Mr. Freeman personally had approved that the video and audio media was ever in evidence. Okay, so that was part of his defense, is he never approved any of that video stuff. He admitted it later under oath, but after filing the affidavit for that case, but before any hearing, I became aware of about $140,000 of bulk mail and print that had taken place. I notified the commission. Okay, there was actually, it involved completely different vendors. A Mighty Group is who did all of the mail and print services. There was ample evidence that became between when I had filed the original complaint in 2020 G19 and when the hearing took place, the hearing started, a bunch of ample evidence came forward that Freeman had directly approved the bulk mail items, and he actually spoke about the program in a candidate forum. There was never any expense on any campaign finance report. It was all paid by Constant Content, a corporation. On September 17th, 2021, Don Bray filed a motion because I had asked for it to be included, because I said at the time my complaint was, I'm being a little simplistic, but that he didn't file a complete and accurate finance report. And this was part of that. And it was, but it got into this debate about, well, what was the scope of the hearings? There was actually a motion hearing on 9/23 that was on, a big part of it was on whether to include bulk mail and print as part of the hearing. So I'm not a lawyer, but, res judicata has to do with, I think part of it has to do with, were things brought forward? I couldn't have done more to bring things forward. It was actually a discussion of whether I should amend the complaint, what we should do. it was ultimately led to that it should be a separate matter. Bray wanted it not included and said it was a very different case. So that's just background on 2020 G19. And just to typify the differences is none of what I put on the screen right now is from the affidavit, from the 2021 G18 affidavit. And there was just all these emails that were involved Alan Freeman personally approving the bulk mail and print. No such things ever existed for the media pieces, the audio and video stuff. Even in the affidavit, you'll find that one of the exact pieces is in there. So the note to the left is Megan Fitzmartin seeking his approval on piece 006. I included images of 006 that he was being asked to approve, which was labeled paid for by committee to Alan Freeman and labeled with the number that they used for tracking the pieces. Just as a background, none of this, by the way, was part of the 2020 G19 case because it ultimately did not include any of this. The bulk mail and print was to be a separate case. Bray made the motion on the 17th, and I put this in my original briefing on the 29th that I did in the middle of the night. And it had, this is where Bray is arguing commission has no jurisdiction because the bulk mail and print stuff were not set forth in the complaint. Any hearing in this case should be limited to matters related to the 6 invoices. Those were 6 media invoices. So 6 media invoices that were the strategic media partner invoices. So again, and then another to the right here, these are all out of his motion from I think it was the 17th of September in 2021. In other words, this case is only about 6 broadcast ads reflected in Mr. Hicks' first affidavit of complaint. So that was the big thing, is whether this was also going to include the bulk mail and print, or that was going to be handled as a separate case, as a separate vendor, separate set of circumstances. And then I get accused here of doing a bait and switch to prevent a vastly different case. So you have Freeman here arguing repeatedly, and they did this is just from the motion, but you can imagine the actual hearing, because we had a motion hearing on this on September 23rd, 21, are vehemently arguing that the mail and print needs to be handled as a separate case, a vastly different separate case. All right, so the commission later had a finding in 2020 G19. I put some clips here from that finding, and all of them make very clear that finding was specific to two things. The television radio advertisements, that's the top thing. And if you look down here enough towards the end, and the assistance of campaign committee you see Stephen Caraway's name at the end of the bottom one, because the only 2 things addressed at all in the 2020 G19 were the TV and radio advertising and the field campaign consultants, R.J. Mancini, Stephen Caraway, and Luke Householder. That was it. Okay, so because all of this stuff, I was not allowed to present any of the evidence relating to this bulk mail and print program, which was particularly damning because I had emails of Alan Freeman approving all this stuff. I was not allowed to present any of that because that was by the decision, by the demand of the respondent to be handled as a separate matter. Okay. So now let's go on 2021 G18. So this is the case before us, just to catch up here. So just as a timing thing, on September 17th, 21, there was the motion from Bray to keep bulk mail out of 2020 G19. September 23rd, we had a motion hearing on that. Okay, I filed the first hearing on 2020 G19 was October 7th. So this whole matter of whether it was going to be included, not included, it was brought up before there was ever a hearing in 2020 G19. There was a motion hearing related to whether it be in or out. Okay, and then on 10/12, I filed the affidavit that became this case, 2021 G18. On 1/29/25, remember in the middle here, I had to file 2 mandamus actions against the commission to get this preliminary review scheduled. There were the 4 Hartman motions on the 29th. We had the preliminary review on the 30th. The day after the preliminary review, circulated to the executive director and Mr. Hartman a draft amended complaint that did only 2 things. All it did was remove 2 bullet points that related to 2 of the 4 allegations, and it made it double spaced because that was one of Mr. Hartman's motions that it needed to be double spaced. And then hearing nothing, getting no feedback for extensive period of time, on March 7th, 2025, I just went ahead and filed an amended complaint that removed those 2 allegations by removing 2 bullet points. Nothing else changed in the complaint. Nothing else changed in the complaint at all, not a word. Okay, so the original complaint of 2021 G18, I think this is why I wanted to make that change and why I brought it up to the commission on the 30th. So there were 4 allegations in the original complaint. One was failure to file a complete and accurate statement. The other one was fail to keep a strict accounting. That was number 2. Number 3 was receiving contributions exceeding the limit. Number 4 was corporate contributions and expenditures. All 4 of those were in there. Now, remember, when I filed this, I had no idea how the case 2020 G19 was going to adjudicate. Just keep this in mind for a second. When I filed this complaint, I had no idea what was going to happen with the reports in 2020 G19. So, because of the fact that a big argument, the only argument that Mr. Hartman has made in anything that he's actually filed is that there's res judicata because you have already determined that the reports were not complete and accurate. Okay, not for the reasons of this bulk mail and print program, but because of the media program. Okay, so you've already, so by the way, it raises an interesting point, an interesting philosophical point of if there were incomplete and inaccurate statements for one reason, and then later another reason came to light, like, you know, while the robbery took place, they also robbed some other stuff. Are they off the hook because they already had, because for other reasons it was determined to be incomplete and inaccurate? But I want to take that off the table. And I said this because I want to make Mr. Hartman stand up and explain how res judicata ever would apply to the 2 allegations, number 3 and number 4 on the top part are what's remaining now, 1 and 2, receiving a contribution aggregating more than the limit from any one individual, and or receiving corporate contributions in violation of the law. That has never been adjudicated. It's never been adjudicated relating to bulk mail. That the respondent specifically wanted bulk mail to not be included. And so I want to take the reports off the table. So we don't talk about the reports because I took those out. And I think I have the right to amend the complaint. You guys have the right to amend the complaint and take out certain allegations. That's what I encourage you to do on the 30th. So because I want to focus in, forget about the reports. By the way, you know, Mr. Freeman has never filed amended reports to correct any of this. He's never paid his $50,000 fine. So but I want to make it so we're not going to talk about the reports, even though I think arguably you could be found to be not complete and accurate a second time on different matters. But let's take that off the table and let's only focus on the allegations of receiving a contribution aggregating more than the limit, 140 grand, okay, or receiving corporate contributions, okay? So that's what I have done. And that's why I thought it was, since you had already voted down Mr. Hartman's motion, it was obligatory on his part to file a motion that actually addressed the allegations. But he won't do that because I don't think he can address those allegations. As to how on earth can you claim that it's res judicata on something that's an entirely different fact set, a different amount of money, different vendors, and where the respondent was the one who wanted it to be handled as a different case. He wants to try to pull a fast one, and that's what he did on the 29th, to throw in stuff, making you think it's only about the reports. So I take the reports off the table, and let's just focus on those other things that you have the authority over, which are not report dependent, receiving a contribution aggregating more than the limit, or corporate contributions. Now, let me bring to a close. I put the 2 statutes here that are the remaining ones. So The first one is, and I apologize for going back and forth, the aggregating more than the amount from one individual. So if in theory these were that were never reported, all the bills were paid, if these were Jeff Longstreth, some sort of contributions from him, it definitely exceeded the limit. Now the statute says 10,000, but you guys know that that's been indexed up, but you still get the point. 140 is unbelievably over the limit. If one were to say this was a contribution from Jeff Longstreth or from JPL and Associates, which is a LLC. But by the way, Alan Freeman testified he had no relationship to JPL and Associates. Okay, so that's the over the limit. So either the 140 was over the limit, and the second one, oh, did I mess this up here? The second one, the corporate contribution, I must have accidentally taken out. The corporate contribution is that I accidentally took the page out for. So that is the 3599. Let me drop back here. 359903B1. Part of that is a candidate receiving or soliciting a corporate contribution. So if it's not, if all this 140K was not an over the limit contribution, it had to be a corporate contribution because all of the bills were paid by Constant Content. This stuff is all known. So Constant Content's a corporation. It paid all the bills. Freeman never amended any finance reports. And so it has to be one or the other. None of the evidence, none of the allegations that relating to this bulk mail and print program have ever been before the commission, because the respondent wanted them to not be included. And I wanted to throw in here, just so to be clear, the penalty schedules for 359903 and 3517102 are different in your own rules. They're not part of the same penalty schedules as a report that's complete. The failing to file a report that's complete and accurate is different penalty schedules. There's a penalty schedule for corporate contribution. There's a penalty schedule for contribution. Actually, what's funny is the penalty schedule for making a contribution over the amount, I had trouble finding where the receipt of that is, but it's actually referred to in your criminal referral to a prosecutor part because it's between the sections of 3517081 and 351713, that would be a criminal matter, but that the fine for that is 1 to 3 times the amount of the contribution. It could be a criminal matter. But so the penalty sections aren't even the same. So Mr. Hartman can't argue, well, you'd be issuing a penalty, the same penalty as the penalty for failing to file a complete and accurate report. It's not even the same penalty sections in your penalties. I want to close, as my last chart, I want to close with these two issues, one relating to Freeman, one relating to Jones. I've said this, but I want to make sure to resonate on it. Nothing that Mr. Hartman has filed has ever addressed 3517102 or 359903, both of which were exogenous allegations in the original, and they're still in the amended complaint. And those relate to over the limit and corporate contribution. And this whole matter around the bulk mail and print was never before the commission at all. It was specifically not before the commission at the demand of the respondent. Mr. Hartman was trying to pull a fast one to try to get you to quick, 11th hour motions. You say, hell yeah, we already did the reports. He wanted to not have to address those issues. He still hasn't. So what I've done is, in the hearing on 130, I wanted to narrow the issues. And so I circulated the next day, but on March 7th, I filed an amended complaint that basically did nothing but did absolutely nothing other than make the complaint be double spaced and to take out 2 bullets relating to the aforementioned complete and accurate and keeping a record of contributions allegations. I just took out those 2 bullet points to make it focused only on 35170102 and 359903, something Mr. Hartman or Ms. Jones has never addressed. Now, finally, on Ms. Jones, she keeps falsely claiming she was dismissed. There was more. She was never dismissed as the treasurer. That's an evidence based on what happened. she filed the final and terminating report of the committee. If she had been dismissed, then there would have been needed to be a new designation of treasurer to change the treasurer to whoever was the new treasurer, and then that treasurer would have filed the final report and the termination. So she keeps acting like she was dismissed, but if she was dismissed, it's kind of strange behavior that you were dismissed and then you still proceeded to do the filings for the committee after being dismissed. And I want to also remind the commission, I don't know that there's, maybe Ms. Tavares is the only one that's still there that was there when this stuff happened, but Ms. Jones was not a party. This was another argument of the respondent, that she was not a party because I hadn't named her correctly in 2020 G19. So to say now that it would be res judicata for her would be completely ludicrous, because by the commission's determination in 2020 G19, she wasn't a party to 2020 G19. So she's never technically been a party to any of this until now, okay? And as an aside, she has done nothing in over 3 months in furtherance of correcting any of these reports, of making changes to the reports after the determination of the commission. And I'll tell you why, and you guys know why, if you want to be honest, is nobody wants to change the reports because they don't have a way to change them that doesn't reveal an improper corporate contribution. So that is what I had to present. Hit stop sharing. I don't know how this works. I don't use Teams. So that is what I had to present as to why this is not, to say this is res judicata, it would be ludicrous when it was, especially when I tried to get it included originally in 2020 G19, and the respondent wanted it handled as a different matter. And the respondent said it was a vastly different matter. And now the respondent's trying to conflate that because the original complaint in this matter had the complete and accurate in the keeping of a record, a proper record in there, that, well, then that means this is res judicata. No, it's not. And I totally want to clear that issue by taking the reporting specific allegations out, which, as I've done in a filed amendment, revised complaint on March 7th, that take out those 2 bullets, which means the only matters right now are probable cause relating to 3517102 and 3599003, which I think there's unbelievable probable cause. Frankly, Mr. Freeman should just admit that this happened and worry more about fixing his reports than taking us on another never-ending set of hearings about something that is obvious what happened, and the evidence is absolutely black and white. Thank you.
Very good. Thank you for the information. Are there any questions of the commission members for Mr. Hicks?
No.
All right. Seeing none, if you would like to respond.
Thank you, Madam Chair. Before directly addressing the res judicata issue, which is clearly applicable in this case, I think we got to be careful when listening to Mr. Hicks, because he tends to have what we call in the law, engage in ipsa dixit. He himself said it, creating facts just by your assertion. And I heard, and he's made this repeatedly in his arguments to Mr. Richter through emails, that the commission has already voted down Mr. Hartman's motions, which is factually inaccurate. The commission will recall at the January 30th hearing, initially, after the motion was considered, there was a motion to dismiss based on res judicata. That went down on a 3-4 vote. Then there was a motion to set it for a full hearing. That went down 3-4 vote. And ultimately, I think it was a 7-0 vote. It was to continue the hearing to allow further briefing. And so that's where we are. So when Mr. Hicks tries to create this fact that the commission has already voted down the motions, it has not, and that is bore out by the record. The other thing I want to just and it's preliminarily, is this: he claims he filed an amended complaint, tried to file an amended complaint. I would recognize that he never sought leave under Rule 15 of the civil rules to file an amended complaint. Which complaints before really doesn't matter, because res judicata clearly is applicable. And it's interesting, res judicata, it's a pure legal concept. And it was interesting, I saw the, Mr. Richter's testimony before the House Finance Committee back in February when the budget was being concerned. And one of the members raised a serious concern. One of the problems they had with the commission was that this commission is dealing at times with significant legal issues beyond the rules of evidence, beyond the civil rules. And this is one of those instances. Yet the problem is most people on the commission are not lawyers, have no training in it. And I even grant you res judicata is not the most easiest concept for lawyers or law students to understand. And so I would warn you or caution you, don't fall into the trap again of ignoring the law. You are a quasi judicial body obligated to follow the law. And in this case, res judicata clearly applies. I don't want to repeat everything I said. I'm going to assume you kind of reviewed what went on in January. But on page 3 of our motion, we set forth the clear elements for the claims preclusion element of res judicata. You know, a prior final valid decision on the merits that occurred in the 2020 G019 case. A second action involving the same parties or their privities as the first. Mr. Freeman is the same. Ms. Jones is in privity. That's a legal concept that there's a close relationship nexus. She's the treasurer, was the treasurer. That is clearly privity. You know, second action claims that were or could have been raised in the first, and that they arise out of the transaction or occurrence, which is a broad concept that was the subject of the first. And it's interesting listening to Mr. Hicks speak this morning, he almost omits all those elements. He admits that this case, quote unquote, relates back to 2020 G019. He admits that he became aware during that earlier case of the mailing expenditure. He said before the hearing, there was, quote, ample evidence. And that was brought up even before there was a hearing in 2020 G019. Res judicata and claim preclusion prevent and prohibits what we can characterize in the law as piecemeal litigation. Well, I'm going to get you here. Once that's done, I'm going to move on to something else, move on and move on. And that's exactly what's done. Res judicata essentially says, once you have a final judgment on all issues that were or could have been raised, it precludes a final judgment on anything further. Even if there are, and I mentioned this previously, even if there are parallel proceedings going on, the first to judgment effectuates all those other cases. And that's exactly what's happened here. Nothing has changed between January and today. The 3 members were understood that then. Some of you wanted to give more briefing. We've given that opportunity. Be it the complaint, the amended complaint, it doesn't have to be precisely the same claims. Were or could have been raised, just arising out of this general transaction. In this case, we're dealing with the 2020 primary, pre and post reports in terms of financing reports, expenditures made, not reported, etc. It's res judicata. The elements are clearly there. And so as a matter of law, I think this commission is obligated to dismiss based on that principle. Thank you.
Very good. Are there any questions? Are there any questions of the commission members?
Yes, Mr.
So, Mr. Hicks kind of explains 2019 was a part of accurate reporting, and now this is a part of kind of illegal contributions. So, and it's going to be a horrible example. I can't think of a better one. So, somebody robs a bank, and they are put on trial for said bank robbery. Goes through, and then during the course of the trial, he admits to assaulting one of the people at the bank that wasn't really known before. Thought was somebody else. You're trying the bank robbery, but information comes forth that there was an assault and battery based on res judicata. Would that not be applicable to try that person for assault and battery? Because it's part of the broader case that is.
All right, so right is that if a final judgment, what is the status of the case? Once the bank robbery charge goes to final judgment,
So if the-
Then it
so-
operates,
if-
it precludes further prosecution on any claims that arise out of it, even if
Okay.
you knew about it, didn't know about it.
So in that horrible example, if that individual was charged with the assault and battery before the judgment, then it's fine. But if it's after the judgment, then it's not.
Well,
Or because it's criminal, it's totally.
yeah, having been a former common pleas court judge myself, I can tell you what would have happened is the indictment would have gotten amended to bring both of them together. They would not proceed in that type, in criminal case, you're not going to proceed in parallel litigation. Civil cases, oftentimes though, you might have parallel proceedings, sometimes in federal court and state court. That kind of arise out of the same events.
Okay.
And what happens there is the first to judgment affects that other case. And that's essentially what you got here. You got two parallel proceedings. One went finally to final judgment. Up triggers res judicata. It's a final judgment that triggers it. It's not while it's still pending, or we'll call it a partial or incomplete interlocutory type thing. A final judgment triggers res judicata.
That's very helpful. Thank you.
Thank you. Nothing.
There are no other questions?
Madam Chair, I have one for Mr. Richter. So I can't find it here, but in the final awards for Freeman, do you have the language on what the award said? I can't find it.
I'm sorry, what do you mean by the?
The judgment against Freeman?
Yeah.
Yeah.
It was a violation and then the commission imposed a $50,000 fine.
No, I understand that.
Okay, that's what, I'm just not sure what you're asking.
I'm asking for what does the final language say? Mr. Hartman has raised an issue that it's final, binding. Basically, I'd like to see the language of that award.
Should I be clear? I might be able to help.
While you're doing, go ahead, I'm going to look for.
Is your question, was it a final judgment or?
I want to see what the language says.
Okay, I will make sure you're not understanding. It's not a one-on-one, hey, this was brought here and you can't bring this thing. It's anything that could have been brought.
I
here.
understand.
It was a final judgment. Otherwise, we would not have been able to appeal that case to the common pleas court and then to the.
No,
10th
I
district.
understand that. I just want to see what the language said. I think that's salient.
I'm not understanding how it would be if it,
Well,
either a
how,
final judgment or not.
well, because you're an attorney and I'm not, so you're not going to follow me.
Well,
Little
I caution
little
you,
levity,
Go back to the House Finance Committee. Issue they had with this commission was not doing legal matters as non-attorney. I'm not
Very good.
besmirching you there.
We don't need commentary on.
Thank you, Madam Chair.
I think that
Fine.
this information is being found by the commission.
Thank you, Madam Chair.
The concluding paragraph, this decision and finding is the final determination of all issues pending before the commission in this case, following the hearing, deliberations held, et cetera, et cetera.
Thank you.
So that, it
That's
takes a
fine.
while to
And I
find.
think
but
that
finding-
language essentially declares this is a final judgment in that case.
Yes.
May I make a comment?
No, not at the moment. Thank you.
Well, you're letting
Sure.
Mr. Hartman just randomly talk. So if you're going to
I'm
maintain
sorry.
decorum.
I'm sorry. This time is restricted for the commissioners to ask questions. That is what's happening at the moment. Thank you very much.
Well,
Are
then
there any
Mr.
other
Hartman
questions?
should only respond to questions he's asked.
I just handled the situation, Mr. Hicks. Thank you very much.
That did,
Are there any questions
That's it. Yes,
remaining of
that's what I,
commission members?
that's what I
sorry,
wanted
it
to
took
know.
me a while. to
Okay,
find-
seeing none, we do have
There you
another
go.
party,
Yeah.
Trevor Stanley, that might like to participate in the conversation. Mr. Stanley, if you would like to be sworn in.
He's counsel for
Okay.
Ms. Jones, so he has an ability to speak on behalf
Okay.
of his client.
Yes.
Very good.
Thank you, Madam Chair.
Absolutely.
So I think the one point I want to make is that Mr. Hicks complains about issues reviewed and determined by this commission in his decision on December 7th, 2022. Same parties, same witnesses, same underlying facts, same reports, same invoices. I think that's the most important key to look at here, is that what he is complaining about is one payment, and he said it himself. All the bills were paid by Constant Content. That was a $290,000 payment by Constant Content, in which this commission reviewed that invoice, took testimony, talked to witnesses, understood what happened. So the way his complaint is laid out in his new complaint and his amended complaint, assuming it's admitted, is that there is a corporate contribution from that $290,000 payment. And if that corporate contribution was accepted and was a corporate contribution, that contribution would have been over the limit. In its decision, in its written decision, the commission, after reviewing and looking at that specific payment from Constant Content, he's talking about vendors and underlying facts, underlying issues, but when you look about it, it's about the $290,000 payment. The commission specifically determined that there had been no violation of 3599.03B, the exact same provision of the statute that Mr. Hicks is now complaining about. So to say that this wasn't before the commission, wasn't decided, wasn't determined, no testimony was taken, no information was discovered, no witnesses were presented, is just not true. So when they went through again, I think there's a lot of things going on right here, but I think we have to focus on what was before the commission at the time and what the commission ruled. So the commission, in its conclusion, found no violation of 3599.03B. And then when you look and go to page 5, it talks about that what was before the commission was this one invoice sent on April 3rd, 2020 for $297.44.63. And one of the key points, and brings it up again in the next following bullet point, and then brings it up again, is the reason to fine Mr. Freeman was, even though had he not known he was responsible, because he had reviewed, Mr. Hicks makes a lot of points about how Mr. Freeman, there wasn't evidence about Mr. Freeman approving these various ads. In that hearing, Mr. Freeman, and Mr. Hicks said this, admitted to reviewing ads, right? So this information has already been before the commission. The commission has reviewed this information and determined, and the basis of the finding was this actual Constant Content payment to pay for these advertisements. And that is in the final bullet point on page 5, where there's a lot of testimony from Ms. Jones as to whether or not it should have been reported, whether what should have happened. And the commission specifically said that they had a responsibility, even though she was to disregard the billing, there were significant services available to Mr. Freeman and the treasurer for the committee to sufficiently alert them that a substantial amount was owed for media activity and other potential in-kind contributions, and believe there was incumbent upon the parties to determine the outstanding amounts owed and to properly reflect those expenses on a campaign finance report. That is the exact same payment Mr. Hicks is talking about right here. That issue has already been before this commission, and this commission levied a substantial fine against Mr. Freeman. And so that, I think that's all I have to say on that point. Again, to have a hearing on this matter, it would be the exact same parties, the exact same witness, the exact same underlying facts, the exact same reports, and the exact same invoices. Thank you.
Very good. Thank you for the information. Commission members, are there any questions for Mr. Stanley?
I have one.
Okay, Mr. Knight.
Does it matter that Ms. Jones was not a party to the last 2019 G complaint?
I think so. So that is that's an underlying issue, but I think she is in privity. And I think that probably should have been the commission's determination. It's sort of a similar scenario as to Mr. Freeman not being a part of other complaints before here, but the campaign committee is. But again, the way the claim preclusion statute determination works from the courts is that she is in privity with the committee. And so there's no way to sort of have this determination without her being a part of it.
Thank you.
Thank you. Any other questions of the commission members? Okay, seeing none, Mr. Hicks, you are more than welcome to address the things that have been brought up that are new. And please keep your remarks to those things. Thank you.
I just want to bring up in both cases and what was just said, the matter, people want to not focus on that. The only matter before the commission in 2020 G19 was the 6 invoices for media things. By the way, there was never a payment of $290,000. There was the entire case, 2020 G19, was about and limited to 6 media invoices, all involving strategic media placement. So the point I want to make is that the entirety of anything involving the bulk mail program was never before the commission. By the way, it was not precluded from the commission because of me. It was precluded from the commission because the respondent wanted it to be handled as a separate matter. You have that evidence in spades all before you. So none of that information, none of the evidence was ever presented. And by the way, it's not the same invoices. The Amity Group invoices are entirely different invoices. It's not the same vendors. The Amity Group is totally different than strategic media placement. So Mr. Hartman, when he talked, he said, I didn't ask for leave to file an amended complaint. Mr. Richter can tell you, I again and again sent emails about wanting to file an amended complaint and what I should do with no response whatsoever. Mr. Hartman brings up that could have been brought, that these things could have been brought up. I tried to bring them up. Mr. Hartman's client wanted them handled as a separate matter. This bulk mail program is completely different. And Mr. Richter, you can go look. There's absolutely nothing in the finding in 2020 G19 that has anything to do with a mighty group, a bulk mail program. It was not before the commission, and it was not before the commission at the request of the respondent to be handled as a separate, very different case. Those exact words, a separate, very different case. What I appreciate the question that the commissioner asked about the bank robbery, but I guess I don't really know this was probably an equally bad example but let's say somebody robbed a bank and then on the way out the door, they assaulted 3 people in the parking lot. Okay, so, and then they requested that it be handled as separate cases. So let's imagine this. The actual person accused a request, well, I want my bank robbery versus my assault in the parking lot leaving to be handled as separate cases. And then when the bank robbery is handled, then that same person saying, well, you can't do anything about my assault in the parking lot. The point is that entirety, what is so brazenly, intellectually dishonest of the counsels involved in this, is that they know that anything related to the print media, the bulk program, was never before the commission. And it was not before the commission because when I raised it to be put before the commission in 2021 G19, the respondent asked for it to be handled as a separate, very different case. And I did, I throughout this, I have done, the record is totally complete as to what was included, what wasn't included, that these things are different, that the evidence is very different, that there are different vendors, that the invoices involved with
Excuse me, Mr. Hicks, for a
totally
moment,
different invoices.
And Madam
I'm
Chair,
sorry.
I would say that, Madam Chair, I think in the briefing and in the earlier argument, we have heard these arguments time and again. I think that it's time to conclude unless there are specific responses to new issues that were raised by the opposing parties, but we don't need more repetition.
Well, I would like to finish my remarks, but I appreciate the interruption. Is the thing I want to say is you saw it with Mr. Hartman. He came up to the podium. He told you were idiots that don't understand how res judicata is supposed to work, and you should, and all these things about the law. Okay, but he did not do anything to address the issue of where then, I would ask either set of counsels to point to you where anything involving a mighty group or the bulk mail program was ever considered at all in any way in case 2020 G19. Then I would like you to ask them to explain how they can rationalize that there was different counsel at the time, but they were the ones that asked that it be handled as a separate case, the invoices, the vendors, etc. But now they want to claim that it was all the same case. It's totally disingenuous, and I would appreciate if you would ask them to clarify how a mighty group, for example, the vendor that did this work, was ever part of the first case, and how they can rationalize that now they say it was the same case and it was all considered when they were the ones that asked for it to be done as a separate case.
Very good. We appreciate your insights. Do the commission members have any additional questions for Mr. Hicks? Okay, seeing none, thank you. As it relates to this case, is there any deliberation or is there a motion at hand? Did anyone have their coffee? The one liberty of the chairmanship is I get to rely on all of you to be leading. Okay, seeing no deliberation, is there a motion?
Madam Chair, what's the recommendation of the director?
My recommendation is act on the motion to find race judicata and dismiss the case. As was the case and as was the original recommendation.
I move that we accept the director's recommendation.
I'll second it.
Okay, seeing a motion and a second, all in favor?
I think we might want to take a roll call.
Okay, very good. Go ahead.
Mr. Lyle.
Aye.
Ms. Tavares,
Yes.
Mr. Knight,
Yes.
Ms. Davis.
Yeah.
Mr. Kirschner,
Yes.
Mr. Stoutberg,
Yes.
Chair Hagan.
Aye.
That motion passes 7-0.
Okay, very good. Thank you all for your time. We'll be moving on to item number 2. Actually, I apologize. Mr. Stoutberg, you are going to be released from your duties, but we need to make sure we have our other commission member here to bring. Do you need to contact Mr. Caraway?
It'll take 5 minutes. As long as it'll take 5 minutes.
Okay, all right. Given the switch over of members, commission members, thank you, Mr. Stoutberg, for your time. Take a 5-minute recess.
I was gonna say is,
Let's not address how we move from here. Only because we got.
Order,
Okay,
thanks for your
that's,
kindness in that longer recess. So we're gonna go ahead and actually address the cases today with the folks that are in the room, bring these parties before us. So for the commission members, we're gonna be on page 3, items 4, and then following items 5 on page 4 for these parties that are present. So that will be case number 2024 G-034, item number 4 on page 3.
Madam Chair, members of the commission. These are cases in which the complainant asserts the respondent failed to establish a proper campaign committee as reflected in a radio advertisement and on certain campaign materials. Yeah. Complaint also asserts the campaign finance reports to candidates and were filed late. We did receive a response in both cases. Those were submitted to you in which the respondent states the two candidates decided to essentially run a joint campaign, produced and circulated joint materials, and it went on from there. So you have been provided with those responses, excuse me. Mr. Leibold is here on behalf of the respondents. It doesn't, obviously, no one, the complainant is not present. I don't believe that we have we don't have a party related to this case online either, I don't believe. I think it's Ms. McKean. And you can see my recommendation in 2 separate cases to find a violation and impose a $50 fine. I can answer any of the questions the commission may have, but the commission can hear from Mr. Leibold on behalf of both of the cases if it's so chooses.
Sure. No, he's just advising that we would hear both 2024 G-034 and 035, allow Mr. Liable the ability to respond to both.
Gotcha.
Okay, if there isn't any opposition to that, I'll go ahead and just permit it. Okay. Very good. All right. If you wouldn't mind, Mr. Liable, we need him to be sworn.
No, he's
Okay,
counsel.
good. Okay.
He's counsel for both respondents.
Okay. Very good.
Okay, thank you, Madam Chairwoman. Thank you, members of the board. Mr. Richter, I'm here, of course, on Ms. Murray and Mr. Harris's request. We would like these complaints to be dismissed. My clients, they filed proper campaign reports. They properly designated a treasurer. They had campaign committees. They had disclaimers on all the activities that are being complained about. It really boils down to, they used a plural disclaimer. They said the committees of, okay, or the committees to elect. They both had separate committees. They both filed separate reports. They use this in almost all their materials, their print materials, their radio materials, their online material. There were a few specific complaints, one involving a Facebook ad. They used their proper campaign committee when they bought the ads with Facebook. Of course, sometimes, as you may know or may take notice of, when you see a political ad on Facebook, sometimes it sort of generates its own sponsored by or some other disclaimer that's different from the disclaimers that they would do when they buy a print ad, for example, where they're actually laying out and approving that. Okay. Same thing with the radio ad. They properly paid for the radio ads using their proper campaign disclaimer. But the allegations here is that it was read something different. They didn't record the disclaimer themselves, is my understanding, that the radio company read the disclaimer. But they gave them the proper disclaimers to read on those ads. As for the treasurer report, there was complaint that their treasurer report or designation of treasurer was filed late. Most candidates in Erie County file in person, in paper at the Erie County Board of Elections. My clients chose to use the Secretary of State's portal, and there were some issues uploading that on time, but I believe it was uploaded the same day, just not by 4 o'clock. But it was a credentialing issue. They did get it in. They did get that designated properly. Again, it's just most candidates up there use paper. They chose to use the portal. Obviously, the portal allows for greater transparency because you can see everything online if you're using that portal. Lastly, something they didn't address in their written responses, I would note that the complaints themselves didn't strictly comply with your notarization standard. In both the campaign finance guide put out by the Ohio Secretary of State and on your own website, it says a proper notarization statement is blank. That is not strictly complied with on their complaint. I'm not disputing that it was notarized. I'm just saying it doesn't strictly comply with the way you guys say to file a complaint and the way the Secretary of State's office also wants to file a complaint. But I have both of them here. If you want to take any testimony or have questions directly to them. If not, I'm here to answer your questions. Again, I think this is rather petty. I think they complied with the law, and I'd hope that you would dismiss these complaints. Thank you.
Very good. Thank you very much, Mr. Leibel, for your insights on the situation. Are there any questions of commission members?
Madam Chair,
Yes.
thank you. I do have a question. So let me just be clear. They had their own individual accounts, correct? With their own individual treasurers,
Correct.
and they worked together on a number of their media buys and brochures and whatnot.
Correct.
But the campaign committees, committee to elect or whatever,
Mhm.
for both were on those joint kind of materials.
Yes, so they each had their own committee to elect Murray, committee to elect Harris. They did not have a formal joint committee as allowed by statute. They had their own individual committees. On some of these materials, they said paid for by the committees to elect Harris and Murray, indicating that there were two committees for two separate candidates. To answer your question?
Yes, it does. Thank you.
Madam Chair,
Yes,
if
absolutely.
I may.
Mhm.
So help me, the two campaign committees, the two separate campaign committees. Let's say they had a sign order and the signs to produce were $500. Did they both write a check, $500 order, they both wrote a check for $250 a piece, or would one write the check for the full amount and then do a reimbursement? I'm just trying to get my head wrapped around how they split expenses.
Sure. It's my understanding that they shared the expenses, okay? That exact detail, I'm not sure whether they would have shared the expenses 50-50, okay? I'm not sure if it makes that much of a distinction, whether they wrote $500 from the committee to elect Harris and then committee to elect Murray paid Harris's committee, okay? I'm not sure if that's a distinction that matters, but I can get you an answer.
Not necessarily. I was just trying to wrap my head around, I don't know that I am familiar with really ever hearing of two campaigns sharing,
Sure.
sharing, the disclaimer, responsibility on one piece of collateral. Does that make sense?
Yeah, no, I understand.
Okay.
But they both had their own committee, all right? And they both obviously had a disclaimer. It's just a combined disclaimer, using the plural as opposed to, the committee to elect Harris and the committee to elect
Mhm.
Murray. Okay.
Yeah, okay.
Instead, they just used, the English language laws to use plural, and it was committees to elect.
Sure.
And they were both running for county commissioner too. So it wasn't as if, you had a county treasurer candidate and, you know, a county auditor, county commissioner candidate. Okay, they're both running for county commission, just the separate seats, you know, they're staggered terms. One starts January 1st, one starts January 2nd.
Sure. Okay. Thank you very much.
Madam Chair, I have a
Yes.
question for Mr. Richter. Mr. Richter, obviously you've heard council's argument that they used the plural when they had the designation on the signs. Does that matter with respect, since they had their own committees? Obviously, they weren't trying to hide anything because they put the committees of. And I think that's important, but I need to know from you, should they have had a separate, or I'm sorry, a joint campaign committee? And secondly, what I'd like to know is, have they had violations before this?
I'll answer your second question first. No,
Okay,
there have not been any priors. If you're gonna run a joint committee, try to run a joint campaign,
Right.
a joint campaign, you should create a joint committee. The statute allows that.
okay,
Honestly, my recollection was back in the day, we haven't had an allegation like this before us in a while, is that the ability to have a joint committee, aside from the governor's office, at one point I thought was only for smaller offices like village council, board of education, et cetera. But when I looked at the statute, it's a broad brush. You can run a joint campaign. But that's it. If you're going to have a joint campaign, you're supposed to have a joint committee. And I don't believe that. I appreciate Mr. Leibold's argument. That's a very good novel argument that he's making. But just trying to say the committees of, that's not a created entity that's responsible for the materials being circulated. And so I don't think that was handled properly. And that's essentially, that's the basis for my recommendation here to find a violation and impose only a $50 fine. I think their intent was not unreasonable, but in my opinion, they didn't go about it the proper way. If you're gonna run a joint campaign, you should create one committee and have a joint committee and put it together. Now, in a lot of ways, if somebody asked me whether I would recommend doing that, I'd say no, because that creates a whole different set of problems and concerns. But to me, this wasn't done properly to have two separate committees and then try and, joint them. Now, had they put on the materials, the committee to elect Harris and the committee, this material brought to you by the committee to elect Harris and the committee to elect Murray, I think that would have been satisfactory, because then you have an identification that lines up with the committees that were created. But try and do it this way, I don't think is proper.
okay, thank you.
Madam Chair,
Sure, Commissioner Hicks.
to the executive director, well, actually to council. So did they run everything jointly together that they did for the entire campaign, or just certain ads? Because I thought you said there were specific things that they did jointly, but they were, I understand it was two totally separate campaigns. But in all of the campaigning, with all of their literature, everything that they did joint, or did they do separate things?
They did do separate things and they filed separate reports.
Okay,
And part of the reason they didn't do the joint committee was, our understanding, if they had done the joint committee, let's say one would have won election and one did not win election. Well, then if the one who lost decides to bow out, they basically have to, our understanding anyway, would be to close down that committee, and then the survivor would have to create a new committee. Okay, so that's the reason they didn't do it that way. Instead, they shared expenditures, but maintained their own separate committees. And of course, they did do I'm sure they did stuff separately on occasion. Okay,
okay,
hopefully that answers your question.
yeah, thank you.
Very good. Are there any other questions? Okay. Sounds like this is pretty simply resolved if it was just two both listed on the same piece, right? So, okay, very good.
Madam Chair, I'll make a modified motion here from Mr. Richter. Find a violation, but for good cause.
Are you wanting to keep that fine in place?
No, he said violation for good cause.
Okay.
Is that are you doing that across both cases? Because they haven't been consolidated, or is that on just like say?
No, I mean, it's just the one in front of us, but if they're parallel, I would do
They're
it.
essentially parallel.
Yeah.
He was
But
speaking about.
they haven't been consolidated.
Right.
would you like to make the motion for 2024G-034 and also 2024G-035C? Now,
Yes,
we're
ma'am.
doing a good job, just like they'll do next time on their yard signs.
Yes, Madam Chair, I will consolidate the motion for both cases.
And I'll second.
Very good. Having a motion and second, all in favor?
Aye.
Okay, any opposed?
Nay.
That motion passes, I apologize, 5-2.
Correct.
Okay, very good. Thank you very much for your time.
Thank you.
All right, we are going to move a little bit around here again to address those who are available online. So we're going to be on page 4, item 16. Tina Butts and Gary Johnson, I believe, are both present for this case. The case number is 2023S-046.
Madam Chair, members of the commission, from here on, we're only dealing with reconsideration matters where requests were made to have cases brought back before the commission after their original termination. We'll get back to that. We're going to deal with the folks online first. Item number 16 is the movement team, case number 2023S-046. They were referred for failing to file a variety of campaign finance reports. All of those reports were filed as of December 14th of 2023. When the commission originally took this matter up back in 2023, the reports had not been filed. The reports had not been filed at that point, but a response was submitted. Subsequently the reports have been filed. And my recommendation is to reconsider the outstanding matter, vacate the previous imposition of the per diem fine, and instead impose a fine of $100. The committee, the treasurer for the movement team committee is Edwina Butts, or Tina Butts is listed on our. I know that I got a call earlier. We got a call yesterday from a Gary Johnson. I'm not sure what his relationship is to the group. But at this point, if the commission wanted to hear from Ms. Butts, you could certainly do so and then be able to move forward from there.
Very good. Tina, since you are present, if you would like to provide any commentary, we just need you to be sworn. Would you like to? Okay, very good.
Do you swear affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay, very good. You have the floor.
Okay, first of all, I thank you for giving me the opportunity. I wasn't really savvy on reports, and I had an attorney that was handling everything. And then once I found out that things wasn't handled, or he said that it was handled, I proceeded to call down there myself. And then he did open the case back up, get a new password. And I asked him to just close it out because I didn't want the movement pack anymore. And he instructed me that I should keep it, but however, I didn't. So I moved forward to asking him to close it out. Needless to say, I got a letter in the mail that said I want $40,000, and I called myself several times and I said I thought it was closed out back in 2023. And they said that it was. And like the gentleman just said, that it wasn't closed out at the time of 2023 when they sent the letter out. But after that, it was closed out. All the reports was completed. I had to get my accountant, which is a CPA, on board to make sure all the paperwork was done, completed. So I just kindly ask you that if y'all could reconsider, trust and believe now, and I'll be on board with everything moving forward. But I did get a letter that said you owe $40,000. I was like, oh my God, why did I get that? Just being honest.
We appreciate you taking the time, and we've often had conversations about scenarios like this. So we appreciate just your visibility and sharing with the commission on this matter. Are there any questions of the commission members for Ms. Butts? Okay, it appears there are none, so you are good. Is Mr. Johnson available or desiring to provide any input?
He said he did not. He was in the chat and said he did not wish to
Okay.
address the commission.
Okay, very good. Thank you, Chris. So, Mr. Johnson does not wish to address the commission. Seeing that, are there any questions of commission members or any deliberation?
Madam Chair, I just have a question of the executive director. Are there any other violations that this committee has had?
No,
Okay, then I would move to modify the recommendations of the executive director and fine at $50.
Second.
Okay, seeing a motion in a second, all in favor?
Aye.
Any opposed?
No.
Okay, that motion passes 5-2. All right, very good. Thank you, Ms. Betts.
Thank
Okay,
you.
and you're very welcome. Okay, and we are going to hop around yet one more time just for our audience and participants online. We're gonna go to page 5 to the last reconsideration category, items number 7, 8, 9, and 10, cases 2015R-094-397, 2016R-206, and also -402. Okay,
Madam Chair, members of the commission, as you can see, this organization had a rather lengthy history before the commission. You see the response that I have synopsized here where, based on all the referrals that we made, the AG's office was trying to make collection efforts to the treasurer for the committee. I think I fairly synopsized the nature of the response, the fact that this PAC was in existence, but then a subsequent organization took over. As the PAC monies were then transferred, no final reports were ever filed for a period of time up through January 17th, 2019, when reports were finally filed. Obviously, in the intervening period, we had a number of cases outstanding. My recommendation is to reconsider all of the outstanding matters, vacate the previous impositions of per diem fine, consolidate all of these matters, and then instead impose a fine of $1,000 as well as declaring the committee terminated. Ms. Middlebrooks is online. I think the commission wanted to hear further from her. We can have her called up. Mr. Hicks, I think Mr. Hughes is going to have a comment here.
I spoke with Ms. Middlebrooks this morning and she was having difficulty. I don't think she has the access to her camera. So if, I don't know that she'll be able to make a statement without having that.
oh, without being sworn. Okay.
Exactly.
Mhm.
So I just wanted to put that on. I can bring her up just to make sure.
So you can bring her up and
Well, if she has to be sworn, do we need it? Can we take that vocally or do we need to see?
our preference is obviously to have a visual, have it as a visual medium, certainly. But I'll leave that up to the commission as to how you want to approach. And if the commission wants to go ahead and be a little flexible, hear from her, we can certainly do so.
Okay, is there a
I'm comfortable with believing that her right hand is up.
Okay, Shayla, our Commissioner Davis is not comfortable, Commissioner Knight is, do we have any other input from commission members? Right now, we're split. All right, well, given that we have a mixed feeling here on the commission, we're going to go ahead and take the conservative approach. Do appreciate you, Trudy, for being present. We apologize that you're not able to be visibly present, to be sworn. Do the commission members have any questions at this time over these particular cases pending for the executive director?
I do, Madam Chair.
Very good, Mr. Fairway, go ahead.
Thank you. Mr. Richter, obviously these cases have been around for a while. Could you tell us, first of all, did this organization at any point respond to the commission, give answers to the commission as to why the reports had not been filed? And further, on the per diem basis, what would they actually owe in fines as of approximately now? And thirdly, and that this committee has currently. Thank you.
Okay, until we receive this response requesting reconsideration from legal counsel on behalf of the former organization of Ms. Middlebrooks, if you look back at all the various priors, in 2009, we did find violation but for good cause not impose a fine in a case there, which was originally a failure to file the 2008 annual. Obviously, they subsequently filed it and submitted a response then. Subsequent to that, if you were to go back through, you could see that we did not receive responses subsequently throughout all of the rest of the cases that we adjudicated as it relates to this particular committee. I have not added up the total amount that would be outstanding, but if you even just glance through all of the findings by the commission, you can see we easily got into six figures by adding those up. And that doesn't even consider the additional interest, et cetera, that would be added on after our referrals to the Attorney General's office. So in an effort to try and be equitable, I thought, a fine certainly was necessary. I chose $1,000 because that's a fairly substantial fine for us to impose in almost any case that we have pending before us. The organization, I'm not sure what the status of the Laborers International Local 860 is. I did not look at that, but this organization was folded into that organization, that PAC, and I think that's still in existence up in Cuyahoga County. But the funds that this group had at that time was transferred from the National Conference of Firemen and Oilers into the Laborers International Local 860, and I want to think it was done in 2012. 2012. And so technically this organization terminated when they did that, but they never filed a report until 2019. In an effort to try and resolve these matters. And in the intervening period, even back in 2010 and 11, when we had matters pending before us where we imposed fines of $50 and $200, nothing was done at that point by the group in terms of responding to the commission or trying to bring the matter otherwise into compliance. So that's kind of where we stand right at the moment. I hope that response is helpful.
It does. My only concern with this, with the $1,000 fine, and I do agree with you that it is substantial. I would have, not having the benefit of this perspective, I would like to have known how much money they had cash on hand at the time it was rolled into the other organization. And then my preference would be to fine them that amount.
I think that, I apologize. I think that was referenced. I want to think it was around $17,000. Here. We actually went back and looked at old campaign finance reports for
And I apologize, Madam Chair and Commissioners, Mr. Richter for lying.
That's all right. We appreciate the inquiry. Relevant.
And Mr. Richter, in fairness to the commission, my comment may not be of concern to my colleagues, and so I don't.
Well, Madam Chair, if I may, and I could maybe offer a suggestion here. We have Mr. Richter previously issued fines for each one of these matters, correct?
Mhm.
So
Yes.
would there be any, you say it's a significant amount to fine, but we routinely issue fines that are significant multiples, Phil, of this amount. would it be improper in any way to simply do what you've suggested here and maintain the current fines as they are? Our enforcement arm is the Attorney General's office, and they can pursue up to the amount that they have available in funding. And if there's no funding available, then it doesn't matter anyway. In other words, adopt your decision, let the fines stand as they are, and let the Elections Commission pursue its enforcement remedies, and if not, allow the Attorney General to. They can't recover any more than exists anyway.
Commissioner, are you recommending instead of the reconsideration directive here of vacating the previous impositions, that you would keep
I mean,
those
I'm
previous
asking if that-
impositions in place in addition to the $1,000 fine being recommended?
Yeah, I'm asking the executive director if that would be an acceptable resolution. If so, I would move to reconsider all outstanding matters, consolidate the matters, declare the committee terminated, and let the prior fines stand as they are. We've already determined as a body that those fines are appropriate. We're just second guessing ourselves here without a real idea of the ability to recover. But if we would declare the committee terminated and let the executive or the Elections Commission and the Attorney General to do its job, they can then pursue any funds that may exist for recovery.
Madam Chair, just a question on that.
Well, I'd like to just hear from Mr. Richter first to my question. Would that be an acceptable resolution because we've already issued fines?
Well, we certainly have. First off, I would say that's not, while it is certainly a manner, an approach that could be taken, it's not consistent, it's not historically how the commission has operated. Let's put it that way. Not to say that we couldn't, but the commission has not operated that way. When we get a request like this, we have brought it back before us, and changed the finding to remove the per diem fines that continue to mount. Well, they would have continued to mount until
They would
the
cease.
reports were filed.
That's right.
But to bring it back to I don't know if I want to say a more reasonable number, but a different number, that puts a specific, identifiable amount, that the individual can pay. In this particular case, the National Conference of Firemen and Oilers no longer exists. They gave their money to the Laborers International, which is not before us. And so the only person that the AG's office could presumably go after as it relates to this would be the treasurer, Ms. Middlebrooks. And one of the other reasons I think why we would adopt a different finding and come to a specific amount like this is really, I guess you'd say, as a benefit to the treasurer, who I don't know what her means are, but to try and have that person subject to somewhere around a six-figure amount, with all the fines that have added up to this point, seems a bit inequitable.
What about
under these circumstances?
What about successor liability? In a lot of cases, for these fines that are due with the Attorney General's office, there are successor liability claims that may exist. For example, to the entity that overtook it. Do you have insight as to successor liability here?
I do not, because that has not been something that has been historically present for the commission. Generally speaking, when we've made findings and then asked the Attorney General's office to collect based on our findings, it's been against the organization. I think, the AG's collection office may be better able to respond to that, but that's not historically what this commission has done or acted when it has taken action in the past.
In any event, the per diem would end with the conclusion of this decision if we issued it.
Well, right now, it technically has ended based on the filings that were made in 2019. But even that, if you look at the last finding that the commission made, which was essentially a year, approximately a year before the final filings were made, the 37,400 at that point would have added another $100 per day, almost $100 per day. So approximately, that itself would be around $67,000 there. And then the other ones would have been there because the reports had not been submitted until 2019.
no per diems have continued beyond 2019.
Correct. Correct. And before anybody else said, they did put that in their response, Mr. Caraway. On March sixth of 2012, the account held $14,134.46, which was then transferred to the labor.
And I missed that. It's been a few days since I was, so thank you.
All right, very good. Thank you for grabbing that information for Mr. Caraway, and thank you for answering Mr. Kirshner's questions. Are there any other questions that commission members? I see trigger ready, finger down there to Mr. Lyle. You're just resting.
I have question, but I'm withdrawing it in my mind.
Okay, very good. Sorry to put you on the spotlight.
No, you're fine.
Anybody else have any questions regarding this series of cases? Okay, seeing none, was there a motion on the
There is
table?
not,
Was that a motion or was it just a question?
It was a question.
Okay. Is there a motion of any commission member at this time?
Yes, Madam Chair, I'll move the recommendation of the executive director that we reconsider all outstanding matters, vacate the previous imposition of the per diem fines, consolidate all matters, and instead impose the fine of $1,000 and declare the committee terminated.
I'll second that motion.
Okay, thank you. We have a motion and a second. All in favor?
Aye.
Any opposed?
Yeah.
Okay, that motion passes 5-2. We are having a 5-2 kind of day. All right, thank you very much, Ms. Middlebrooks. You have a wonderful day. Okay, we're going to resume the agenda in the order of which it was previously laid out. So we are going to move to page 1, item 2, Deacon versus Grand for State Rep et al. Case number 2024 G-018. Phil, do you have?
yeah, the complaint was originally before the commission. We did not get good mail service. Subsequently, we sent out regular mail service indicating that they did not come back to us as undeliverable. So therefore, I believe we have the ability to go forward based on our rules. Complaint asserts that the respondent failed to file campaign finance reports. In my review of, and this was against obviously Grand Acre State Rep. In my review of the Secretary of State's office records, the reports were filed. They were late. And so my recommendation is to find a violation and impose a $150 fine.
Madam Chair. Question of the executive director. Mr. Richter, has this candidate or committee had other violations?
No.
Thank you.
Okay, very good. Are there any other questions? Okay, seeing none, is there a motion?
Madam Chair, I will move to accept the recommendation of Mr. Richter.
Okay. Is there a second?
Second.
All right, the tide is changing. All in favor? Okay, all opposed, seeing none opposed, that passes unanimously. Thank you. Okay. Moving on to item number 3, case 2024 G-020. Would you like to share, Phil?
Chair, members of the commission, this too was a continued matter from a previous meeting. After getting certified mail service back, we subsequently sent out regular mail. Was not returned, so therefore our rules, we have the ability to go forward. The complaint asserts that the respondent failed to file certain campaign finance reports. Report Madison. Okay, so this was in Franklin County. I checked the records of the Franklin County Board of Elections, and there has still not been any filing done by this campaign committee by the Dowdell-Berger for Madison, Groveport Madison schools. And so my recommendation is to find a violation and impose a fine of $25 per day, but give the candidate the ability to have the matter reconsidered upon the filing and the submission of a request for reconsideration.
Okay, very good. Are there any questions of the executive director?
Madam Chair, just one question of the executive director. Mr. Executive Director, have you had any contact with the Franklin County Board of Elections on this particular case, the school board candidate?
I did not call or be otherwise in contact with the Franklin County Board of Elections. I looked at the online records.
Okay, thank you.
Very good. Are there any other questions? Okay, seeing none, is there a motion? Don't be shy now.
Madam Chair, to move the day along, I will make said motion. Thank you.
I'm devastated for your lack of passion and excitement on the matter. I do appreciate your willingness to be prudent. Is there a second?
Second.
All right, very good. We have motion and a second. All in favor? Ooh, man, you guys are falling off quick and fast. All right, any opposed? Okay, seeing none, that motion passes 7-0. We're gonna move on to page number 4, item number 12, under the reconsider the matter, vacate the previous imposition of the per diem fine and instead impose a fine of $100 category for case number 2022R-357.
Madam Chair, members of the commission, we received requests for reconsideration on the 2 matters mentioned. The reports have subsequently been filed, and a request was submitted to the commission requesting that. And so you see my recommendation to reconsider the respective matters, vacate the previous imposition of a per diem fine, and instead impose a fine of $100.
Okay, very good. And Bill, for the record, I would go ahead and include case 2024RG-029 in that matter. If it, so will the commission consider them together?
Madam Chair, I'll move the recommendation of the executive director.
Second.
Very good. All in favor? Any opposed? Okay, very good. That motion passes 7-0. Moving on to the next category, for items 15 and 20, cases 2023R-470 and 2024R-358. Reconsider the matter, vacate the previous imposition of the per diem fine and instead impose a fine of $100.
Madam Chair, members of the commission, while there are 2 cases, recommending that they essentially be consolidated. The report have been filed. A request for reconsideration was submitted to the commission. And so my recommendation is to reconsider the matters, vacate the previous imposition of the per diem fine, consolidate the matters, and impose a fine of $100.
Okay, are there any questions? Seeing none, is there a motion? Very good.
Second.
Very good. All in favor?
Aye.
Okay, and so for those, seeing none, that passes unanimously. Okay, we're moving on to items 11, 14, and 10, cases 2022R-295, 2023R-158, 2024R-287. Bill, would you like to speak to these cases?
Madam Chair, members of the commission. This was a request we actually received from board staff, had been indicated that they were working with the candidate. A filed designation of treasurer but never reached the ballot. As his petitions were incomplete. A candidate informed them that he did not raise or spend any money. So this request for reconsideration essentially came from the board. And so out of respect to that, to the efforts the board has made to bring the candidate into oh, gee, evidently I'm having a hard time thinking here. Into compliance, my recommendation is to reconsider all these outstanding matters, vacate the previous impositions of the per diem fines, consolidate the matters, and instead impose a fine of $250 and to declare the committee terminated.
Okay, very good. Are there any questions? Seeing none, is there a motion?
Move to adopt the recommendation of the executive director.
Second.
Very good. There's a motion and a second. All in favor?
Aye.
Any opposed? Seeing none, that motion passes 7-0. Okay, moving on to case number 2022R-385 and 2024R-229. Items number 13 and 19. Phil, do you wish to expound?
I will gladly do so. I'm just double checking on 229. 2022 R-385 is also out of respect from a request from the Board of Elections to have the matter reconsidered. Their indication, I'm looking for it. They've been working with the treasurer. A mid-year report was filed with all zeros. Treasurer was informed that he did not raise or spend any money, and so out of respect for the request from the Board of Elections, I am making this recommendation. As it relates to 229, we did receive a request from the candidate requesting reconsideration, in which the candidate essentially said she's very confused. Additionally, the candidate decided not to run after opening the committee and keeping it open. Candidate resigned from her position due to health issues. even suffering a stroke in 2024. And how much the substantial fine amounts would be a burden. You can see all the various priors involved here. And so I'm recommending, though, that we reconsider all outstanding matters for both of these separate cases, vacate the previous impositions of the per diem fines, and instead consolidate the respective matters, and impose a fine of $250 and declare the committee's terminated. I'll be glad to answer any questions the commission may have.
Very good. Are there any questions?
I'll move to adopt.
Is there a second?
Second.
Very good. All in favor?
Aye.
Any opposed?
No.
Okay, that motion passes 6-1, I believe. All right, very good. Moving on to the final matter at hand today, number 18-2024R-153. Mr. Executive Director, you care to share? Well, he's gonna, I'll read the title for you. Reconsider all outstanding matters, vacate the previous imposition of the per diem fine, consolidate all matters, and instead impose a fine of $700.
We received, excuse me, Madam Chair, Madam Chair, members of the commission, we received a request to have these matters reconsidered, and the reports have been filed as of January 4th, 2024, along with dealing with elderly parents and their recovery from various ailments, and in addition to COVID diagnoses, as well as work responsibilities, and each file campaign finance report was initially overlooked. Campaign was essentially self-funded. Candidate worked with staff at the board to figure out and resolve all the issues, subsequently filed reports. And so my recommendation is to reconsider all outstanding matters, vacate the previous impositions of the per diem fines, consolidate the matters related to this campaign committee, and impose a fine of $700.
Madam Chair, just a question of the executive director. Is this the first violation of this?
No, this is 1, 2, 3, 4, 5. There were 6 priors. We did impose a fine of 2014 of $500 that was paid. Then subsequently we had case 2019 S035, 2021 S041, and then this matter 2024 R-153, in which the commission found violations and imposed per diem fines. And so those have occurred subsequent to the last fine payment, 2014.
Thank you.
Okay, very good. Are there any other questions?
I did talk to Mr. Van Ho briefly. I indicated to him that I did this on the record. He and I chatted for a while. He was initially asking for a continuance of the matter potentially because he was traveling to today's meeting. I told him what my recommendation was. I certainly can't, I never guarantee to anybody that my recommendation will be accepted. But after our discussion, he said to allow the matter to just go ahead and go forward. So he is not here online or present, but he did indicate, his respect for the commission, and, his willingness to appear if it was necessary, but he was not dissatisfied, I would say, I guess, with my recommendation.
Thank you. Very good.
I'm sorry, did you say he was or wasn't satisfied?
He was.
Was not dissatisfied.
He was not.
Yeah. Mr. Caraway.
Please feel free to stand on your head.
Thank you.
Mr. Caraway, are you asking for it to be on the record that somebody respected us? Sorry, very good. Okay. All right. Do we have a motion?
I'll move to adopt the executive director's recommendation.
Second.
Very good. All in favor? Any opposed? Okay, that motion passes 7-0. Very good. Seeing that there is no other business.
I'll move to adjourn.
Okay, very good. We have a motion. Do we have a second?
Second.
Okay, all in favor?
Aye.
Aye. Any opposed? Okay, wonderful. Thank you very much. That is unanimous.